right, crim 28, here we go with chapter 1, overview of community corrections, goals, and evidence-based practices. No, I'm not going to read every single slide like this and bore you all to death, so don't worry about that. So you'll see that the cover of the book looks just like this slide, and so we're going to move on to the next slide with the learning objectives, blah, 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 blah. You can read that. Okay. The correctional dilemma. This may be shocking to some of you, but approximately 7 million people, or 3% of the total adult population, are under some form of correctional supervision. If you think about just the city of Fresno, there are about 500,000 people living in the city of Fresno. The county of Fresno, about 1 million. So this is 7 million people throughout the United States who are under some form of correctional supervision. That's huge. And the United States has a significant number, in proportion to other countries, of people under correctional supervision. Now, that does not mean that there are 7 million people in custody. And actually, the majority of people under correctional supervision are actually under probation supervision. So probation and parole are two forms of community corrections. And community corrections differ from institutional corrections in that community corrections are where an offender will be hopefully rehabilitated while they are residing in the community. As opposed to institutional corrections, a person will be rehabilitated while they are living in a correctional facility like a prison or jail. So this class, we're going to focus on community corrections. This is a probation parole class. So most people who are on probation or parole are not in custody. They are living in the community, being supervised by a probation officer or parole agent, and they are working on their rehabilitation within the community. These community corrections can take place pre-adjudication or post-adjudication. So what does that mean? Well, before a person has been convicted of a crime, that would be called pre-adjudication. So that means that they're still going through the court proceedings and they have not yet, their case has not yet been resolved. And there are times that corrections becomes involved in cases like that. Bail, pre-release supervision, things like that. And post-adjudication, you can see that I'm doing these out of order because I think they should be flipped, but post-adjudication community corrections, that would be much more like your standard probation or parole, where a person has been convicted of a crime, sentenced, and they're being supervised by a person like myself in my former life when I used to be a probation officer, on probation or parole. So what is probation? Probation is a sentence handed down by a judge where a person is basically committed to prison, but that commitment is suspended, and they're given an opportunity to rehabilitate in the community under the supervision of a probation officer. Now, if they don't take care of business and don't do what they're supposed to do, they can be, their probation can be revoked and they can be sent to prison. Your book defines probation as community supervision of a convicted offender in lieu of incarceration under conditions imposed by a court for a specified period, during which it retains authority to modify those conditions or to resentence said offender if he or she violates those conditions. Of course, I'm getting 300 emails while I'm doing this, and it is a Sunday afternoon. But anyways, so sorry about that. So let's move on. We're going to talk about different styles of sentencing. First, we're going to start with indeterminate sentencing. And indeterminate sentencing was the primary model between 1930 and the mid-1970s. Indeterminate sentencing is it's a range of time that an offender will spend in custody. A good example that I always use, it's really easy to understand, is a murder sentence. If you were convicted of first-degree murder, your sentence would be 25 years to life. So we know that the minimum amount of time you're going to be in custody is 25 years, but the maximum could be up to life. The actual term of the sentence depends on the parole board. They get to decide when you get out. They get to decide when the offender is rehabilitated and no longer a danger to the community and allowed to get out of custody. So between the 1930s and the 1970s, basically every crime was sentenced with indeterminate sentencing. So you could commit a petty theft and end up in jail for 3 years if the parole board didn't think that you had been rehabilitated. So there was ultimately the purpose for indeterminate sentencing was to encourage good behavior while a person was in custody. That was the premise behind indeterminate sentencing. They wanted to encourage good behavior while people were in custody, so if they did really well, they would get out early. However, it kind of backfired in that people sitting on the parole board sometimes, unfortunately, weren't perfect human beings or were bad people and maybe racist, maybe didn't like sex offenders, maybe didn't like thieves. And so they were biased when they were making their decisions for release. So, indeterminate sentencing. Now, let me clarify this also. We still do use indeterminate sentencing for serious offenses in California. We use determinate and indeterminate in California. Probably going to be a quiz question. So indeterminate sentencing, we still use that for charges like murder in California. But lower level offenses, theft-related offenses, there will be a set time for the offender to be released. They're not going to have to wait for the parole board to decide when they have been rehabilitated. So an example of an indeterminate sentence, 25 years to life. Determinate sentencing is basically the exact opposite. An offender is given a very specific period of time for which they will be held in custody, maybe 3 years, and that's a standard felony. So if an offender is convicted of a felony, there is absolutely no way they will be held in custody longer than 3 years, period. Now, is it likely they'd get out earlier than 3 years? Yeah. But is it possible for them to be kept longer than 3 years? Absolutely not. So determinate sentencing was fair. Everybody who commits a burglary stays in custody for such and such period of time. So you can see the difference between the determinate and indeterminate sentencing. Pretty significantly different. And again, in California, we use both of these for the more serious offenses, indeterminate sentencing, and for what we would consider less serious offenses, determinate sentencing. And when we talk about the origins of determinate sentencing, you'll see that there are obviously some bullet points here. American Friends Service Committee, they recommended that sentences be categorized according to the severity of crime based on 2 scales: the harm done by an offense and the offender's culpability, not capability, culpability. And then this David Fogel guy, ultimately what his main concern was, he had concerns with indeterminate sentencing in that there were inherent biases, and certain people, usually people of color, were being held in custody longer than those who were not of color. So he urged for a narrowing of sentencing and parole discretion. He really wanted to see changes and wanted determinate sentencing to be imposed so that all offenders were treated equally, and that discretion was kind of taken out of the picture. Mandatory minimum sentencing. There are certain offenses for which judges have zero discretion. This is also part of determinate sentencing. So no matter what happened during the crime, no matter how some part of the criminal offense tugs at someone's heartstrings, it doesn't really matter. Judges in certain crimes have zero discretion. Truth in sentencing laws. This refers to federal crimes only. So truth in sentencing laws state that if you are sentenced to prison in the federal system, you will do, is it 85% of your sentence in custody. 85%. Because of truth in sentencing laws, we no longer have federal parole. I know, crazy, right? We've all heard of 3 strikes. 3 strikes is a law that actually started in California and actually in Fresno. And I believe, gosh, the guy might have died recently who started it in Fresno. Anyways, 3 strikes law ultimately was that you could commit 2 serious violent felonies followed by another felony of any sort. And if that happened, you, the offender, would be sentenced to prison for 25 years to life. So these are all very kind of limiting sentencing laws. And there are a lot of sentencing guidelines that are set forth just in the law in general. Oops, I want to go to the next slide. There we go. Okay, the paradox: correctional policy shifts between what we can afford, changes in public perception, and what is important to vocal constituents. Public opinion about community corrections, and prison is expensive. Okay, so the pendulum, as I call it, has continues to swing back and forth about what we should do. We as Americans in the criminal justice and specifically in the correctional system should be doing with offenders. Should we lock them up longer? Should we offer them more rehabilitative services? What should we do to be more effective in reducing crime rates? Unfortunately, at this point, we have learned that basically nothing that we have done has worked. Back in the 1990s, the crime rates were climbing, getting crazy out of control. And that's when 3 strikes was imposed. And so we started locking people up longer and longer and longer and longer. What happened then was that our prisons got really full, and the crime rates didn't really drop. So it was kind of counterproductive. In the few decades before the 1990s, like in the 1970s, we were using the medical model, where the thought was that offenders were sick and they needed medical treatment in order to stop committing crimes. So rehabilitation was the main goal then. We also learned that that did not work. People in general in the community, after some polls were done, have agreed that they believe that a lot of offenders, as long as they're not violent, should stay in the community. And there are a lot of positives to that. Families get to stay together then. Offenders can stay employed and continue paying taxes and be productive members of society. But when it comes to violent offenders being released into the community, public opinion is obviously not in favor of that. If we as a community knew what type of offenders were out in our community under probation supervision, I would be willing to bet people would be shocked. Having worked at probation and knowing the types of offenders who are living in our neighborhoods, I guarantee a lot of you would be shocked by the number of violent offenders who are out in our communities. It's scary. And prison is expensive, very expensive. And it costs about the same to send someone to prison as it does to send someone to Stanford. So these are all very contradictory and confusing and frustrating facts that make corrections complicated. Okay, so major role of corrections at 3 major decision points. Corrections become involved in the criminal justice system when bail is a question. The jails will bail people out, will allow for people to be bailed out, or they don't actually bail people out. Hopefully you know what I mean. People are eligible for bail. They get bailed out. Bail has also been a pretty significant issue that we will talk about a little bit more later. But sometimes offenders can't afford bail. And what recently has been taking place is that probation officers have gone in, assessed offenders to see if they are high risk to reoffend. If they are not, then offenders are being released without bail under probation supervision pre-adjudication. So probation officers are getting involved even before a person has been convicted. So that's number 1. Number 2, after an offender is sentenced and they are placed on probation, corrections is definitely involved then. Or if they're sent to prison, of course, corrections is involved at that point. And number 3, at reentry. What do we mean when we're talking about reentry? We are talking about an offender leaving prison and reentering the community. Leaving prison and reentering the community. And that is a really important step, making sure that the offender has the services available so that their reentry into the community can be smooth. Couldn't be much more important than it is. So like I mentioned earlier, pretrial supervision, there are some key points to it. Obviously, the goal is to make sure the person returns to court. And the probation officer is responsible for making sure they know where the offender is, making sure that this release allows the defendant to prepare for their court case. It allows for them to keep working. It allows for them to maintain good relationships with their families, which is not listed on here. But it also leaves bed space for violent offenders to remain in custody. So there are a lot of pros to it. There are some cons too, because some of these offenders will go out and reoffend and victimize other people. So it's tough. What's next? Let's go. Come on. There we go. Sentencing. The vast majority of offenders can be punished in the community, and that is absolutely true. Most offenders, like I mentioned much earlier in this recording, are sentenced to probation, to community corrections. The majority of offenders are not sent to prison. When we say intermediate sanctions, we are talking about something other than prison. So there are a lot of different things that could happen instead of prison. And that's what this class is going to be about. Okay. And they will take place in the community. Reentry is challenging. I have a former student who was a murderer, and he was a lifer. And he had a second-degree murder charge, and he had 17 years to life. And he got paroled. And I asked him about reentry, and he had told me that early on in his time at CDCR, offenders were given 3 months of reentry services, meaning before they got released, they were sent to a different facility so that they could thoroughly prepare to be released back into the community. He got 8 hours of reentry services to get released back into the community. He had been in custody for something like 23 years. So if you can imagine being in custody for 23 years and only being given 8 hours of preparation to get released back into the community, it was completely inappropriate and not at all sufficient. Your book makes it sound like we have lots of reentry services. We kind of do, but so many offenders are being released from CDCR that it is impossible to give them all proper reentry services. And it is the parole board who decides who is getting released early from prison. The judges basically have nothing to do with that. All right, and these are, generally speaking, the goals behind community corrections: to protect the public, to rehabilitate the offender, to heal the victim, and through the participation model, to include the offender and the community in the offender's supervision, rehabilitation, and all that kind of stuff. These all sound amazing and fantastic. And I'm a little bit jaded, having worked in probation for quite a while. I am aware of some probation officers who have up to 1,000 clients on their caseload. So it's near impossible for one probation officer to properly supervise and provide services for all of these offenders. But this participation process model is basically assumes that the offender wants to get better. And I think a lot of us probably know that a lot of the offenders are only going through the motions so they don't end up back in jail. However, when we do have the ones that want to participate and work the programs, they're successful. Evidence-based practices, correctional programs and techniques. Basically, what these are is we do research and studies to see which programs are most effective. How do we decide which programs are effective? We check recidivism rates. What is a recidivism rate, you ask? Recidivism is when an offender completes a correctional program and they re-offend. So let's say I have a probationer on my caseload, and or they're still in the program, and they get arrested for a new law violation. Or they complete probation, they get off probation, and then they get arrested a month later. Those are recidivism rates. That means that they are recidivists, meaning they have not been successful. So recidivism rates are basically how probation departments, parole agencies, criminal justice system, researchers decide which programs are effective. And we will talk a lot more about evidence-based practices in community corrections and my experiences with those as well. So this is just an overview of community corrections. Probation and parole, two very different things. Parole is an early release from prison by a parole board. Probation is a sentence ordered by a judge where an offender is given an opportunity to not go to prison at all. And I'm getting too long, so I'm going to stop there.